allowed to hear one such phone call. Any objection, Mr. Bloodworth?
No objection, Your Honor. Are we good then to, as we discussed at the bench, have Mr. Shervinack just give the date of the phone call?
No, Your Honor.
It's not in the content, and Ms. Gibson didn't provide that particular piece of foundation, so that would be additive.
Your Honor, if we were to play that portion of the audio of the jail call, it would make it clear that it was a jail call.
Oh, forgive me. I haven't heard or seen the introductory portion of the home wave call. Does it?
Right, Your Honor.
The date? Yes,
every home wave call begins with a time or date, and then, this is a recorded line, and anything you say will be preserved, could be monitored, and admonishments like this.
Is that accurate, Ms. Lewis?
That's accurate, but this takes me back to my initial point, is this should have been, and typically would be, introduced through a witness, because the witness could have just said the date, and we wouldn't have this problem. I don't think that the state should be testifying to the date.
Right, but if Ms. Gibson had just said, in order to avoid playing any of that for an indisputably authentic call, I will now just list the dates of the calls, would we be in any different position than we are right now?
Well, I would stand by my objection that a witness needs to testify to the date of the call, not the court or the state.
Yeah, given here the effort that we're taking to not put evidence that Ms. Richins was in custody in front of the jury, I think it's in fair and necessary balancing to not play the preamble of the call, which would limit your ability to cross-examine Ms. Gibson as to how she knows when the date of the calls, because it's based on that same content. And so I think it's appropriate and does not violate defendant's rights in any way to just eat what is undisputed. December 18, 2023, correct, Mr.?
Oh, that's correct, Your Honor. I also think the date falls, because of the way the calls are labeled, the date falls under Jeremy Thomas's certification as to the authenticity.
I understand. I think you and I see it the same way. It's just a matter of the defense's good faith objection to me providing the information, but given the alternatives, this is the best way.
Yes.
Okay.
One more
Please.
Pragmatic. Because the court's decision just redacted out the initial part of the demonstrative, it seems to make sense to the state to, at this point in time, as a matter of efficiency, to just kind of fast forward and hit play beginning at page 4, line whatever the court just decided.
Yeah.
Rather than take 15 minutes to redact the exhibit now, and then at the end of the day, we can redact it and clean it all up consistent with the court's ruling.
Ms. Lewis, you okay with that? You're not waiving any objections?
Yeah, I understood. Yeah.
Okay,
so Scott's way ahead of us.
Scott, why don't we take a look at it together? Show me the new version of 2-95D.
Obviously.
Who fucking cares?
I know. I'm just so annoyed by that. I'm like, what the hell are you talking about? Who gives a shit?
Yeah.
Obviously, one party's going to do it, the other party's probably going to do it to see what the fuck.
Do you want to fast forward to the end just to confirm? So Ms. Lewis can confirm that the stuff at the end has been redacted out? Yeah, if you would work with Scott real quick to make sure that the stuff at the end gets redacted out. Hey, you say it's redacted. It's the way it's being offered includes redaction.
What'd you say no to?
Oh, yeah, I don't know.
Like I said, they're talking about it, but guess what? So it's everybody's natural reaction to one kind of fault.
That's correct.
Okay, give me one moment.